Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. It's back to the future when it comes to employment regulations. The National Labor Relations Board officially brought back its 2020 Joint Employer Rule, and the Department of Labor proposed a new independent contractor rule that is largely the same as its 2021 rule. Epstein Becker Green's Aaron Schaefer tells us more about the NLRB's newly reinstated joint employer test.
Under this test, the company is a joint employer only if it actually exercises substantial direct and immediate control over at least one of an employee's essential terms of employment. Those essential terms are wages, hours, hiring, firing, discipline, supervision, and direction.
This test has been the de facto rule since the previous administration's efforts to change it were blocked by the courts. So, Aaron, what does this action to formalize the test now change for employers?
Companies are now less likely to be pulled into joint employer liability litigation based solely on contractual provisions or claims that they have indirect influence. This is going to be especially important for franchises, staffing companies, and subcontracting relationships that employers may be entering into. That said, direct involvement in core employment decisions can still create exposure, and so your clear contracts with defined boundaries are going to be important as much as abiding by those terms in practice.
Epstein Becker Green's Jeff Ruzal explains what's happening at the DOL.
On February 26th, the U.S. Department of Labor proposed a new independent contractor classification rule that would rescind the Biden administration's 2024 rule. This new rule revives the business accessible framework of the Trump administration's 2021 rule. The proposed rule focuses on two core and generally determinative factors, namely control and opportunity for profit or loss. Subordinate to the two core factors are three additional factors: degree of skill, degree of permanence, and whether the work is part of an integrated unit of production. In addition, and importantly, the DOL stresses that the focus should be placed upon the actual practice of the parties, rather than any contractual or theoretical control.
Thanks, Jeff. What are the next steps for this rule?
The NPRM is presently open for public comment for 60 days, which closes on April 28th, though it's difficult to predict when after the close of the comment period the rule will be published. If history is any indication, it's possible that the 2026 rule will be published relatively quickly.
Thanks, Jeff and Aaron. And thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.